Welcome, everyone. Thank you for joining this CLE program presented by the Beverly Hills Bar Association, the Labor and Employment Law section. My name is Jeff Bills. I'm chair of the Labor and Employment Law section, and we have a couple of excellent speakers today. Before we get to that, I just have a couple of brief announcements regarding the bar. We have three structures here at the bar for membership that you see on your screens. The middle one is particularly helpful for new attorneys and for law students, which, as I understand, it's offered for free. But we have something that is a good fit for anybody, professional level, sustainer level, and economy level. And next slide, please, Alex. And in addition, one thing the bar has made available that's particularly timely right now is a business address. This allows you to have an office in Beverly Hills with an address and continue to work remotely, or come in to have a virtual office with a lot of services added to it. For details, just contact the bar. I should mention as well, we do have the network, which is a wonderful opportunity to network with other attorneys and develop business relationships and referrals, opportunities to refer business to one another. It's a great way to meet other people and one more service that the Bar Association offers. So I'll introduce our two speakers. We have a couple of speakers with a massive amount of trial experience for this advanced trial skills presentation. Elisabeth Frater is partner at Burke, Williams, and Sorensen with over 25 years of litigation experience and a deep background in employment law and litigation, business litigation, administrative law, workplace misconduct, and EEO investigations, and criminal law. She's a trial lawyer who's represented individuals, officials, businesses, and government entities in more than 125 jury trials throughout California. Our other speaker, Hillary Johns, is the owner of Hillary Johns Trial Lawyer, based right here in Beverly Hills with offices in the Bay Area. She has tried more than 100 cases to verdict and practices in the areas of employment law, business law, entertainment law, and civil litigation. She's a member of the California and Washington D.C. bars and will be the succeeding litigation section chair of the Beverly Hills Bar Association. We thank you both for presenting, and I'll turn it over to you.
Thank you. Can we first start with the first slide, please? Greeting, everyone. We hope that this is going to be a very elucidating program for you. As Jeff mentioned, Hillary and I have a lot of trial experience, and we would really like to share one of the things that's made us successful, which is developing and using trial themes. Would you please go ahead and do the next slide? Next slide. So what we hope to accomplish today is to tell you about what trial themes are. Why trial lawyers use them, try to expose themes that your opponent is using, and using themes at various stages. Now, you may in fact have a background with themes. It may have been something that you've used organically, but hopefully we can give you a framework so that you can go ahead and have a conscious effort and use them effectively. Next screen. Specifically, what are trial themes? Well, they're a mechanism that you develop hopefully at the beginning of your case. And why are they helpful? Well, they're helpful because they're a tool of persuasion, because ultimately you want the jury to decide in your client's favor. In essence, they're oversimplified, and they're based on the evidence in the case. What you need to do and what your overriding goal should be is to provide the jury with the better theme. And that's one of the things that Hillary and I hope to explore, is the themes that are going on, maybe consciously or not consciously. One of the things that we want you to understand is that they have to be easily remembered, easily repeatable, and it's basically a statement that you're going to be making to the jury and it's something they can cling to as they strive to organize all the material you're going to be giving them. So if you have looked on the internet in the past to try to find out what a theme is, you might be misled because a lot of those articles say that they should be movie titles. And I think that this is a wrong approach. And instead, Hillary and I are going to try to give you a practical approach. Next slide. So why do you want a trial theme? First, because jurors are wired to decide the case on their own emotional sense of morality and fault. So no matter what information you give them, they're going to still decide the case based on their background or, in the alternative, clues and cues that you give them. One of the interesting things that research shows is that jurors feel very qualified to decide the typical kind of litigation case, which is employment, personal injury, or civil rights case. Do you agree, Hillary?
I do, and I know that we had talked about it in our preparation. I've actually interviewed jurors informally and talked to people even on airplanes, and they all talk about the same thing. They go, I want to know how this affects me. I can make this decision, and why am I here, and why am I getting engaged? But I think the jurors in large like to feel engaged and that they're in control in making these decisions. And that's why these points that you're making here are so important.
Thank you. Next slide. So these are themes that can help you stay on message. What they do, once you've developed one, is they help you to cull the evidence, because you're going to find that in most cases that your client is going to turn over dozens and dozens, if not hundreds of documents. And you're going to determine that not all of those documents are going to be important in the presentation of your case. One of the guiding factors is if you have a theme, you can decide whether or not that particular document is helpful or not. It's another way of controlling the case to give your client an advantage. In other words, you want to make sure that you're preventing your opponent from defining the issues at trial. Because once they define the issues at trial, then the jury is more likely to be persuaded. What you want to do is you want to have an organizing principle from the beginning of the case that elucidates the jury about where you're going and why you're presenting certain evidence. You want to give the jury the impression that will support the evidence that they want to use. You want to be able to answer the rhetorical questions in the jurors' heads. And this is very important, I think you'll agree, Hillary, is that you want to assist your presiding juror during deliberations. So, Hillary, maybe you can go ahead and elaborate on the importance to the presiding juror.
I think the presiding juror, when they're there, you can often get a feel for how they're responding. You can take a look at their faces. You can read how sometimes how they're responding. But you need to give them, you need to balance the line between sort of giving them a map or answering questions, which I know you're smart people, things like that. I know this is a lot of work to do, and sort of putting it in their hands without, people don't like to be treated like they're stupid. You know, they want to say, oh, I'm figuring this. Oh, okay, yeah, you know what? I saw that. And I know that we've talked about this, Elisabeth. I think one of the reasons that shows that crime shows, court trial, any kind of legal show are so popular is because people feel engaged. They feel like they're part of the story, they're involved in this. And a lot of people like a good whodunit. And even if it's not a flashy murder case, they want to think through and they go, oh, okay, you know what, I know that. And I think there's also, we're fortunate we live in a country where I think there's a sense of pride where people say, you know what, I'm figuring this out and I see why this is important and I see why I'm important to be there. So if you can engage them early on and make, as you're saying, sort of giving them those ideas and answering those rhetorical questions, a lot of jurors I found are more than happy to move things along and be involved because they actually feel like they're making a difference. They, you know, maybe a person who comes in and sits on the jury says, well, I don't know, I vote, but whatever. And they're like, oh, wow, I get to actually affect the outcome of something. And a lot of people respond very favorably to that, I think.
Thank you. Next slide. We're going to start talking about developing a theme and how you come up with one that's going to work. So the best themes answer the question about the whys of human nature. Why do people do things? Why are people motivated by things? Why do people lie? Why do people exaggerate? That's ultimately what your theme is going to answer. It's going to be the framework for all those human nature questions. You're also going to find that it may evolve over time as you get more information. You want to, of course, take a party's deposition at the earliest time because you're going to be looking for inconsistencies in the evidence. You're going to be looking for alternative reasons for the actions by the different parties, the motivations of the plaintiff, the motivation of the defendants. These are going to lead to your theme. And you're going to want to test these out with the witnesses during your witness interview. When they give you information, throw it back at them with your theme and say, is this a possible explanation for why this is happening? You also want to test them with lay people. In any case, they take time to develop, and you have to be flexible to come up with the right theme. In the end, they're the moral of the story. Next slide. These are also general principles about your theme. The components for a successful theme are they're easy to understand and memorable. They're holistic. They're general and they're not targeted to a specific claim or event in your case. They also have to evoke an emotional reaction. They must draw from life experience and they must be consistent with the evidence. Hillary, I think that's what you were talking about earlier about the emotional reaction of the jurors. Can you elaborate on that?
I do. Yeah, a person is far more likely, just in real life experience, and you don't even have to do a study on it, say, if this is affecting me, oh, wow, that's something I'm concerned about. Maybe not for me, but for someone I know. And for example, if you have a wage and hour claim case that you're trying and you have people here and they're like, I don't really care what happened in this company. But then maybe they're looking at the bigger picture going, oh, this could affect me. This could happen to me. And maybe I'm helping to influence a decision, which would be helpful. And I know that we'd also talked about easy to understand and memorable. I agree with you wholeheartedly that a movie title doesn't usually work. It's too long, it could leave them hanging in a situation they don't like. But small things quicker, like if you look at an advertisement and if you've ever just turned off the sound, you're going to see like flashing messages and things like that. If you have very short messages that you're sending to the jury consistently, which is your theme, and interweaving those, like they're far more likely to remember that and say, wait, I can relate to that. Like, I mean, the classic would be the O.J. Simpson trial. If the glove doesn't fit, you must have quit. Things like they're going, okay, I'm engaged. I get that. And I think also from real life saying, this isn't just an isolated incident. This is how it affects you. And this is why it's important that you as jurors are making this decision. You almost have to make it about them in a way to get them involved.
One thing that Hillary and I wanted to emphasize is that these techniques and this framework works for both the plaintiffs and the defense. So it is our goal to try to give tools to both sides. In my experience, I've mostly been a defense lawyer, although I have done plaintiff's work. But in my opinion, having done a number of trials, I believe that the plaintiffs are generally better at this. And I would hope that the defense could learn to be able to do a good job at trial. Do you agree, Hillary?
I do. I think by and large, plaintiffs' attorneys, they have to make their prima facie case. They've got to prove it. So they're going to go after it a bit more than I think a defense attorney, where a defense attorney may be inclined to say, well, I don't really have to do anything. You have to prove it. I can just knock you down all day. And I'm not saying it's not effective, but the better defense lawyers that I've seen tend to go out, they're almost prosecuting their own case. And by the end of the case, if they do their job effectively, you could be thinking, well, maybe the plaintiff should have been sued in this case. So I think an aggressive defense is almost always more beneficial. The sort of sitting in it's going, well, I don't really have to do anything. Hey, you're not going to prove your case is not, I don't know that that's a winning strategy, and I think there's a lot of risk involved. And frankly, if you're a defense counsel, someone is paying you to do this. I don't know that I'd be real happy as a client if I was sitting there going, well, what exactly is my attorney doing? And hey, come on, you know, it's if for no other reason for client control and things like that. And I think that juries like to see action. I think that there is the perception that lawyers are not very interesting, and they're talking about things that have, you know, legal concepts and things, and they can't really relate to it, which goes to the draws from the real life experience that you talked about in your fifth point there. Jurors need to know, well, I don't really care about, I know sort of the law, I'm not a lawyer, I don't know. You know, if you can put it to a real life experience there, they're far more likely to be engaged.
Thank you. Next screen. So as I said, generally I believe that plaintiffs' attorneys are better at developing a theme that will resonate with the jury. Some of the themes they use that you may recognize, or maybe you haven't recognized, were that they put it into a dichotomy of either good, evil, right, or wrong. And obviously their client's going to be on the side of good and right, and my client's going to be on the side of evil and wrong. They also are very effective in saying that the defendant has a higher duty to the process, to law, to society, and that they're thumbing their nose at the law. They're also going to look for ways to make a theme that says that due process was denied. And you also see that plaintiffs' attorneys are very effective in whistleblower cases, because when the theme involves whistleblowing, they can put the employer on trial. And we're going to show you more specific ways that they do that. Next slide. This is a magazine that's available by subscription to plaintiffs' attorneys. It's also, the past magazines are also available online. And what you'll find if you review these is that they're very good at instructing plaintiffs' attorneys to start framing the case or start developing the themes very early, certainly earlier than the MSJ. So one of the things that they'll do is that they'll coach their, or not coach, they'll direct their client, or they'll prepare their clients in a way that the clients understand what the theme is, and so that their answers are generally consistent with the themes. So if you have the plaintiff, you want to make sure that you've communicated the theme to them and that you have given them the bigger picture. Next slide. Another specific tool that plaintiffs' attorneys use that's very helpful and very elucidating is a concept known as rules of the road. This is a book that you can get on Amazon for $135. But basically what it does is it sets up the themes that are easy for the jury to understand. And most often this will apply in a tort case, for instance, or an employment case, medical malpractice. They find that these kinds of approaches with the rules of the road are very effective. So what the premise is that you want to have a theme that focuses on rules, and you want to convey to the jury that the theme is that the jury must follow the rules of the road. And the book tells you how to come up with these rules of the road. Because what they explain is that most of the jury instructions are very confusing in torts cases and employment cases. And if you're a practicing attorney, you'll probably realize that a lot of the instructions direct the jurors to determine what was reasonable. And what plaintiffs' lawyers developed over time is that the concept of reasonableness is very difficult for jurors to comprehend. And so if you're able to give them exact rules that are in writing, the jurors are more likely to start their focus on the rules as opposed to the bigger picture. So for instance, you might find if you're representing a hospital or an employer or any other defendant, they're going to ask for all of your policies. And what you're going to find is that during the depositions of all your key witnesses, they're going to keep directing them back to those policies and try to use the policies as the theme and the framework. And in essence, the theme is going to be that the defendant did not follow the rules of the road, harmed the plaintiff, and thus is liable. Next slide, please. Another thing that plaintiffs do, thank you. Another thing that plaintiffs do that's very effective and that all attorneys should do is to come up with labels. Because as we stated before, in these cases, sometimes the evidence is complex and it's hard to assimilate all the facts. But if you label the plaintiff and the defendant in certain ways, it'll make it easier for the jurors to recall events. And so part of developing a theme is also to have labels for all the players. For instance, I often represent state agencies and city agencies. What the plaintiff's attorneys will do is label my clients as the government, as the state, and they'll label the plaintiff as the victim or the underdog. This is a mechanism of further developing their theme, which is normally that the employer or the defendant didn't follow the rules. Hillary, do you agree?
I do, and I know that we had a very productive conversation the other day, and I would also say, you can, in certain cases, if you have good facts or a sympathetic plaintiff or defendant, and I'm thinking specifically of two examples. We have a case right now, very sad case that we're on the plaintiff side. We refer to her in the first name, and everybody. We had a hearing on this. We've had an administrative hearing. The LAPD is involved. There's a civil matter and two civil matters going on. Her name is her first name, and everybody is identifying with her. You know, it's sometimes that does work in these situations where she's clearly the victim. She's clearly been wronged. There's clearly awful things that happen here. It's all about her. Conversely, I know on defense labels, I know it's not a little off subject. Sometimes as a defense tactic, which has worked effectively, for example, we represent a physician who is an ICU attorney or ICU physician, and he is literally working every day to save lives. So he is the hero who is on the front line saving lives. And it's something that people are buying into. We've seen reduced offers for settlement. It's probably going to go to trial anyways, but things like that. If you have, sometimes the point being, those are two examples of where they're particularly compelling, appealing things that people are going to go, oh, I want to know what happened here. But I think you're right. And generally speaking, it's a good idea. The labels will start distinguishing people, and people think, you know, you want to know why they care about this person. Why do we care so much about what happens here, other than I have to sit here and get paid for the $10 a day now? Jurors, it's nothing. I mean, but they're giving up their valuable time for a civic duty. And why do they care here? And if you can make them care about this person or identify with them in a specific way, they start thinking about it.
Thank you. Next slide. Here's another theme that you may have come across. It's commonly known as the reptile theory. The reptile theory. And in essence, even though it's not a classic theme, it is an underlying theme that your opponent is using to gain an advantage and to direct the jury's attention in a certain direction. The way this theory works is that the reptile approach suggests to jurors that they should award compensation to punish the defendant and to deter others. So, in other words, they are trying to evoke the reptile brain that we all allegedly have, which is concerned with safety. So, for instance, I used to have a client that was a state hospital. And I saw this theory effectively used because what they did was the other side would bring in photographs of hospital patients, state hospital patients, and to try to scare the jurors and to try to give them the impression that the plaintiff had always been in danger. And I think that this can really be an effective way of having the juror relate to your client. How about you, Hillary?
Yeah, I agree, and I think it's human nature to act in your own self-interest, but in particular, most jurors are going to want to relate to this. And if there's something like, oh, this is going to affect me, I could be next. This will happen to me or someone I know or someone I care about, or maybe just someone, I see exactly why this is a problem. So if you can hone in on that part, the reptilian part of the brain or whatever one just sort of kicks in and go, the person goes, wait, we want to put a stop to this. We're concerned now. That's the button you need to push. If that's what you need to appeal to these. And like it said in the introductory comments, Elisabeth, the evoking an emotional reaction, because this is probably the strongest reaction you're going to get. Most people are not going to put themselves in harm's way, and they're going to think about that first. They're not going to go head on into traffic. They're going to say, okay, what do I need to do here? Wow, I hadn't thought of it that way.
If you detect that this is a theory that your opponent is using, you have to take some really proactive steps. One of the things is really know the policies, your client's policies, and really make sure that the witnesses know these policies backwards and forwards, because it's going to make a big difference. The other thing you want to do is you want to prepare any persons most qualified to understand these policies and to be able to explain how they work. You also want to be able to effectively utilize motions in limine to keep out the reptile theory as much as you can. Now, as part of this presentation, you will be getting, if you haven't already, some materials. And the materials that Hillary and I provided to you include a couple of theories on the reptile theory and a motion in limine that we've come across that was very effective in limiting the attorney's ability to appeal to the juror's sense of security. Thank you. Next slide.
And Elisabeth, I appreciate you getting credit for everyone there. Elisabeth prepared those. She did a super job on all the materials. I think the motion in limine I thought was particularly good. If you haven't read it, I would really recommend that you do.
All right. So what does an effective theme have in common? Well, you want to find that the theme addresses attribution. In other words, the theme should direct the jury on who's to blame. Do you agree? Do you agree, Hillary?
I do. People are going to want to know who's responsible for this, depending on how a person's mind works. Who's responsible for this? Who's at fault? Who is it? Your fault? Who did this? They're always going to want to know that who done it. And people don't like to be confused. They want a clear picture with your theme about why this, if you're the plaintiff, why this employer is the bad guy, or why this hospital is the bad guy, or why this individual is the bad guy. Or if you're on the defense side, you're going to want someone to say, you almost have to flip it, which is the classic defense move, where you say, look, we understand this is a serious societal issue, but this didn't happen here. If you have, for example, someone who's just looking for a quick payout and wanted to settle, and maybe you could get in, for example, how much higher, 20%, I think it's like 20%, the insurance rates are 20% higher because of bogus claims, things like that. But people are going to want to pinpoint who is involved here. The last thing you want with a jury, unless maybe it's a criminal matter, is for the jury to be going, I'm a little confused here. You did this, what are you saying happened, and why do we have to sit here and figure it out? Aren't you supposed to prove that to us? I think you absolutely have to be clear on who's liable, who's not, or who's making a claim that doesn't have a lot of merit. This is probably the most essential thing that you have that we have in the presentation here. That you've got to make sure that it's not us. We know this is a problem. There's other examples. I'm sure you have. I know I've successfully used other examples of liability cases if the judge will let it in. It's and saying these are examples. We're not saying it's not a problem. We're saying in this case it isn't. If you're the defense or if you're the plaintiff, saying, look, you need to put a stop to this, and you need to send a message today, and you have an opportunity to do that, ladies and gentlemen of the jury.
Thank you. That nicely segues into the next slide. Next slide, please. So one of the most important points we want to make is that you need to be proactive and not reactive. And so when I was a new lawyer, I probably came up with themes just organically, but typically it didn't happen until closing argument, when I would, in my own mind, in preparing for the closing arguments, kind of assimilate all the information and assemble them in my mind about what is the guiding principle here, right? So, but that's a mistake. I think that's a rookie mistake if you wait until the end. Another thing that you want to do is you want to make sure that from the very beginning, from the first depositions to your MSJ, you want to make sure that you make sure you are able to convey that the reason why the jurors should vote for your side. Right, Hillary?
Yeah, I think that's absolutely right. And I think that lawyers have a tendency to say, oh, this is a really good case. I've got these really good points on the law. This is great evidence. You'll see how it all comes together. Don't assume the jurors are going to. They are nowhere near as invested in this case as you and your client. You need to get, I mean, right out of the gate, this should be what you're talking about when you mean proactive is, this is going to come to this. You're going to see this later, even if it's, if you can make a comment, say you may see this later. I know we're going to, if you can with a witness, we're going to see some evidence later here. So to the extent you're not leading, and sometimes I cross that line, you absolutely have to do that. You have to have the themes. You need to make it clear in your opening statement why these themes are going to become important. I want you guys to think about this and why this works this way. But you have to start at the beginning. They're going to want to know the why, and they're going to want to know the details, and they're going to want to know what they need to do. And you absolutely have to do this. If you don't do it, the person's going to go, I like them, again, important, they like you too. If you sense you're losing the jury, you need to do something soon, which we're going to talk about later. But you sort of need to know, they want to know what they're dealing with. And you need to be clear. Sometimes you'll get feedback going, I wasn't really sure what they meant, and they seem smart enough, but I don't know how it relates. So you've got to help them with this. That is absolutely a trial attorney's job.
All right, thank you. Next slide. Here are some themes that we have seen and successfully used. A theme might be, well, the witness was out to get revenge. It might be, if you're representing the plaintiff was set up to fail. Another theme might be, the plaintiff was incompetent, and that is why you should fine for the defendant. And another theme might be, the defendant sought to reduce costs at the expense of a plaintiff. What you can see from these themes is that they would never serve as a movie title. They're more a very simplistic way of approaching all of the evidence in the case. If you're saying that the witness is out to get revenge, it's an opportunity for you to explain away perhaps inconsistencies in the evidence. If your theme is the plaintiff was set up to fail, then it's a very good blueprint for all of your depositions of all of the people that either worked with her or and the same thing applies if your theme is that the plaintiff was incompetent. This is also a good blueprint for you to use during your depositions and then ultimately in your closing argument. Next slide. Other themes that we've seen that were useful and very effective were that the plaintiff's complaints and injuries were ignored. I'd like to talk a little bit about a very bad fact. This is something that you can actually turn around if you're using themes. I had a case where we had, it was an employment case, and one of the managers and one of the defendants used a very bad word to describe the plaintiff. And this was something that really should have caused our client to lose. And we did take the case to mediation, and we weren't able to settle it. So what we did was we went to trial. And the way we were able to successfully use it was to bring it up early and often. And so what our theme was that, yes, this word was said, but it wasn't said because the plaintiff was a woman. It was said by this manager to many different people. So we started at voir dire by asking the jurors, if you heard the witness call, or any of the witnesses called by a very bad word, and we actually told them what the word was. It's not a word that I would say here, but you can imagine what it was. And we asked the jurors, and we made sure to ask every single juror, if you knew that one of the witnesses called another witness by this name, would you be able to be unbiased and still decide this case on the facts? And after getting the assurance from the juror, then we selected that juror, or police didn't kick the juror off. And ultimately, this worked out to the benefit of our client. So our theme, as I said earlier, was, yes, this word was said, and yes, this supervisor shouldn't have used that word. It still wasn't discrimination. So that is one successful story to illustrate how you can use a theme when you have a bad fact. Another theme that, and really this doesn't really only apply to plaintiffs, is that one of the witnesses' version is fiction. It's most successful when you can successfully use it against a plaintiff, because if you can at least give the jury, if you can give the jury at least a couple of provable instances where the plaintiff was dishonest or mistaken, then you can persuade them that what occurred is fictional and therefore they should not fine for the plaintiff. Next slide. Now, some of the defense themes that we've seen that were very successfully used were that the plaintiff was not competent. So this would be most successful in an employment case where the plaintiff was actually treated fairly in comparison to others. Next slide. Another way to use a defense theme is to talk about the greater public good. You can say, well, in fact, yes, this did happen in this case, but it actually is for the greater good. I'm going to cough, so I want Hillary, if you could take off on that theory.
The greater public good, you're thinking of society as a whole and why this is important to have this sort of policy or this sort of practice and things. For example, just as a for instance, it's not per se a theme, but when you thank the jury, it's say, look, you're the reason people's property doesn't just get taken arbitrarily. You're the reason the Gestapo doesn't show up at your front doorstep, and you are the reason this happens. They are the reason in defense of things. For example, insurance rates is one that is persuasive to a lot of people because it hits their pocketbook. The insurance, yes, we have insurance coverage, it's true. Yes, we have a lot of insurance. Do you know how much your insurance rates go up every year across the board because of meritless claims? This is why it affects you. You think we're paying for this? Society as a whole is paying for this, and someone's not getting treatment because of this person's claim. There's another litigant who maybe has a valid claim who's not getting into court today, and maybe it's going to be too late. Those kind of things. I agree. I absolutely agree. Anything that is fiction, I think, is always a good part, saying this person had a lot of motivation to make this up. They saw an easy score. This is unfortunately for employment law cases are very common these days. It used to be the slip and falls in the 90s. Now it's the employment law claims. They all say they didn't get their break. They're all saying that they didn't get their lunch. They're all saying they worked overtime. And they figure, hey, an extra $15,000, $20,000 to me when I have a low-paying job is exciting for me. I'm not saying there aren't legitimate claims, but greater public good, like there's someone out there who has a claim who doesn't get to court today because of this. You've all wasted your valuable time, things like that. Your tax dollars are paying for this. So you understand those things like that appeal either to financial concerns or someone else not being treated fairly because they're not getting into court today, I think is very persuasive. And even if the jury doesn't like your client or is like, they're like, okay, yeah, that is true. And if you can, even if a jury, for example, doesn't seem to be going your way, to hate your client, and looks at how cute the plaintiff is and goes, oh, she's so cute or nice, it must have happened. That's not always the case. If you can start looking at these things and appealing to their greater good and to what this is really costing them too, there are ways that I think are very effective. And lying is always, it didn't happen, it's just a lie and they wanted some cash, is always good and always effective.
Right. And then the last column refers to the hard facts. You probably know that not every case seems winnable. And sometimes if you're representing a particular client that has done something that wasn't upstanding or isn't a good fact or isn't good optics, you may have to make tough choices. And at least I always consult with my client first and make sure that they're okay with this approach. But if you can get the go ahead, sometimes you have to let the client fall on their sword and say, yes, it's true, this supervisor used this terrible word and we have a zero tolerance policy and it never should have been used. But even assuming that he said this word, still our actions of releasing this particular plaintiff was not based on the fact that she was a woman. Hillary, have you ever had to use the technique of falling on the sword?
I have, and it's my least favorite because you're sitting there hoping that it works. And I think, you have to be, there's the clear CYAs and being clear with the client. But I think when, in the long run here, if you ignore a bad fact and you don't hear from that person, the classic is the criminal case. Why isn't he testifying? He or she testifying? They must be guilty. If you don't address this problem, this squarely on, the plaintiff, one, will exploit it, and two, the jury is inclined to think you're hiding something. So it is usually much better, even if you're the defense, you don't get to go first, so it's going to come out. But I think part of your trial strategy should be, this is a bad fact and we need to talk about it. Yes, it looks bad. Was this, and maybe you have to, for example, the bad word, maybe explain, say, look, we've all had situations where we've thought something like this and probably said something we wish we hadn't. That's all this was here. We're not saying it was appropriate. We're not saying it was professional. It wasn't. But the reason this person was let go or terminated had nothing to do with that word or an attitude in the company. It had to do with she wasn't doing her job. He wasn't showing up to work on time. They made mistakes that cost the client money, and you sort of flip it into, I think you have to make it relatable. And I think when you fall on your sword, you have to make it relatable as we all make mistakes. This was an error in judgment, but it has nothing to do with the liability. And if you can do that, you've got a successful defense thing. And any good trial lawyer, particularly defense, plaintiffs too, has to learn this. Because if they don't, it's, people are going to say, look, if you can't deal with the hard facts here, why would I want you as my attorney? And why should we believe a word you're saying?
Thank you. Next slide. So that dovetails into what Hillary was just saying about giving context to the juror. The themes have to give context. And one of the questions you can ask in a case, even where you have bad facts, is why are we here? The theme is, why are we here? And that's the message that's going to come out in your opening, it's going to come out in your voir dire, and it's going to come out in your questioning of all the witnesses. And if you're lucky enough to have a case where somebody is exaggerating, and in the cases that I handle, it's usually exaggerations by the plaintiff, but you can also use this against the defendant. If you can explain to the jury that the reason you are they're sitting as jurors is because of the exaggerations by a party, I think you've accomplished a lot in a short time. Next slide. Another way to develop a theme is to focus on who has control of a particular situation. Now, this is going to be very fact specific. If you have a medical malpractice case, it's arguable that the hospital had the control. But if you have a case where the plaintiff's family or the plaintiff herself did not reveal all the facts or all the previous ailments, you might be able to have your theme be that the plaintiff is who actually had control here. Next slide. So one of the questions we often get asked is whether or not you can successfully call a witness a liar. And so this really applies when you're saying that it is the plaintiff that has to blame, that it's the plaintiff that's to blame, or that the plaintiff has exaggerated. Is it too risky? Is it possible? Hillary, what do you think?
I think, you know, Colin, it's good that you're asked. I know we've talked about it. I just had an extensive conversation with a colleague of mine yesterday. Excuse me, we're living in the golden age of pets here. You're definitely, if you call someone a liar and it doesn't work, it definitely is a risk that you need to discuss with your client. But that being said, there are other ways to do this. There is the mere fact of asking the question. You know, that's the classic defense and plaintiff's move. Even if you ask them, even if they say no, no one's going to believe that. You know, you really have to. And, you know, there's the, I think you can do it with indications and say, look, what you want is the jury to say, look, we're not stupid. We're all smart people here. We all know what's really going on. And then I think you have to. And it's, I mean, in this day and age, you do run the risk of course, calling mistrial. It doesn't usually work the way you see it in the movies and on TV. Oh, you're lying. Oh, come on. You know, it's going to be more, sir, there's this. In your closing, you could say no reasonable person's going to believe that. If you believe him, that can't possibly be true. And I'm like, but you could in your cross say, for example, so you expect us to believe X, Y, and Z, right? Yeah, but I think you absolutely, in certain cases, it's well worth the risk. And I think you have to go. So if you don't go for it, they're going to be like, you know, if you can't move in for the kill, I mean, because sometimes that's what it is. The case is over. I know we've discussed this. Sometimes there's a fact, once you hear it, they're not going to hear anything else. The jury's just going to turn off. They go, we've already made up our mind. It takes a lot of practice, though. I think it's certainly it's a skill set that can be developed, but it's not, I don't think it comes naturally to most people. But I think if you're going to be a good trial lawyer, the one where I'm like, oh, so good, I have to go up against Elisabeth today, great. You know, that's what you want. Frank, what do you do? I think you have to be able to do this, and effectively.
I think it can be one of the most effective themes you can have, that the complaining party is exaggerating or lying or fabricating. You don't have to use the word liar. There are a lot of other pseudonyms you can use to describe that, and other ways you can suggest it. You can suggest to the jury that the plaintiff is looking for deep pockets, is looking to be set for life. That's something that jurors latch on to. So use them. Don't be afraid to use that theme. Next slide. A very similar theme is that it's not an outright lie, but that it's a house of cards. In other words, that perhaps what the plaintiff is now saying, or what the what the defendant is now saying, is not actually true. But you're attacking the foundation of what they said. And that allows you, to, without calling them a liar, to say, well, they were mistaken. The reason why they brought you here today is based on their incorrect assumption that the reason why they didn't get that promotion was because they are a woman, or they were a woman. So that's just another alternative to use. Next slide. I want to talk a little bit about a trial that was in the media a few years ago that very successfully used themes. And there's been a lot of articles written about the themes that were used because there were a lot of reporters that were there. And basically, next slide. What Ms. Powell said was that there wasn't an even playing field for men and women at this particular firm. But ultimately what the jury found out was that, what the attorneys found out after the fact was that a lot of the evidence that they had been presented was irrelevant. Next slide. The defense themes that were very successful in this case were that the employer had a very good record overall with women, that the plaintiff in this case had a history of a very poor performance, that the plaintiff had a very bad attitude. They exploited the fact that her story had changed over time, and since it had changed over time, they decided, or the jurors decided, that she had been plotting revenge the entire time. And another theme that they successfully used was that there was no pattern of sexism at this firm. Next slide. This is just some practical advice as we are wrapping up this particular presentation. You might have a great theme, but you also have to be aware of what's happening around the world at the time you're presenting this theme. I can give you a very concrete example where I was actually not aware of this. In our case, the employer was, the supervisor was white and the employee was black. That was a fact, and it had never really been an issue. It was a performance issue. But at the time of trial, there was a lot of news going on about abuse to immigrants in our country. So where in the past, year of this case, there had never been a theme from the other side that there was a race issue. It had always just been performance. But since they had the opportunity, given all the news, they suddenly started referring to this particular plaintiff as an immigrant. And that really had an appeal. And so this is an example of a last minute theme that was developed by the plaintiff that was extremely successful, one that I did not anticipate going in and hadn't prepared for. So just by way of a warning, just be thinking about your themes and don't be surprised if the other side switches their theme to coincide what's going on in the world. Which leads us to our last question. Next slide. What's the backup plan? Hillary, what are your ideas about that?
Well, I think thank you, Elisabeth. I think the issue is here, what if your case is bombing and the jury's not buying it, or there's a problem with your theme and it's not working with the evidence, and maybe there's some very bad fact that comes in, or a witness just does not do well. Are you going to have to change course during trial, and how are you going to do that? And I think at the planning stage, sometimes things come up that really are unanticipated. There's an undisclosed person, if you can't keep it out of evidence, and there's some document out there that you're like, oh dear God. Other than that, I think and I know Elisabeth, you and I talked about this, you've got to have a backup plan, which you've discussed with your client before trial, because sometimes you have a situation where there's a bad fact, or there's been bad testimony, or the jury's falling asleep and their eyes are glazing over, and you can tell they're not engaged and they could care less, or maybe they don't like me, or they don't like the client and they need to do something. You've got to have a backup plan here. And the backup plan, at least one, is how you're going to approach this if your case is going south. And you need to do it quickly. There's a few ways you can do this. There's one, if you can't do anything else as a last resort, put it in the closing and say, I know we talked about this, but I want to offer you a different perspective. What if it happened this way? This is why, you've seen this, you've seen this, you've seen how the plaintiffs put it together, but what if that's not true? I mean, there's a way to put that together. But frankly, the sooner rather than later is always better in these situations. If you're fortunate enough where the judge is convening for the day and you can do your cross tomorrow, great. Say something comes out in direct that's just awful and you're going, oh dear God, the jury's eating this up and they can't take their eyes off the testifying party, and they want to punish someone because they're mad now, or that's not going to, or sometimes a witness just isn't a good witness. Sometimes a witness may have very good things to say, but they're not a good witness. And that happens. Maybe they're freaking out. Maybe they don't come across as credible. Maybe they've got something in their personal history or done things before. You need to plan for this. If you're fortunate enough to get a break for the day, you're going to be working late at night and discussing that with your client. If you can't, you're going to have to pick up the pieces. And if you can get a recess, that's great. But if you can't, you're going to have to proceed. And sometimes you have to switch gears almost mid-trial. And you need to be prepared for it. And that's why you almost have to learn 2 cases. And sometimes the cases are very related. So you're not having this it can be a very gentle or simple transition. For example, if they're talking, you could just sort of say, look, I'm going to offer you this perspective. Could this have happened? Maybe you can ask some questions to that person. The jury goes, oh, so it's not as bad as I thought. That's not so bad anyway. Okay, I could sort of see. You want to make it relatable to the jury, but you've got to have the backup plan. And again, it depends on the facts of your case, but again, discuss it with your client, because the last thing you want, particularly as private practitioners, is a malpractice claim from a client going, we never talked about this and you never said anything. And, if they're freaking out going, you're losing the jury or whatever's going on, you need to have this backup plan. But one effective way is almost like the cleanup at the end, but you run the risk that the jury is going, well, that's not what I thought you were talking about. Why am I hearing this for the first time? But I think you have to run these scenarios through, and you have to think them through about how this could look and how this could play. And we've all had these conversations as lawyers, like you'll have a 30 or 40-minute conversation, you go, oh, I guess that's not going to work. But at least you've thought about it and you've thought it through and tried to be logical and take in all factors into consideration. Elisabeth, what have your experiences been with backup plans? How do you use them effectively?
I go back to that original checklist that we showed the audience to begin with, and I just make sure that if I have to come up with an alternative solution about why they should fine for my client, that I make sure that it's actually reasonable, that it fits with the facts, it's holistic, and it answers the why question about why people act certain ways. I think if you stick to those basic principles, even if you have to change horses in the middle of a stream, at least you have a chance of getting a verdict for your client if you follow those principles. So at that, I think we're out of time. We really appreciate you attending this presentation. It was a pleasure bringing it to you.
And thank you, Elisabeth, for all the lovely materials in the back. You guys should take a look at them. They're good articles. They're very instructive and very informative.
Thank you very much, everybody, for attending. That was a wonderful presentation, and wishing you all a great rest of your day.
Thank you.
Thank you. Stay safe, everyone.